Yes, Mr.
May it please your lordships, I appear with Dr. Barron, Mr. Lunt and Mr. Vangemala for the patentee appellants Astrazeneca, and Mr. Mitchison appears with Ms. Pickard, King's Counsel, Mr. Austin and Mr. Ganser for the various generic companies. Well, before I begin, can I just express thanks to the parties for your lordships are going to sit a little bit early each day so we can get through.
No, the thanks are the other way. Thank you for accommodating the court. I'm sorry that it's a full court, and I sense that it's going to get quite warm. If it becomes difficult for parties or anybody else, would you just let us know? We can either have a break, which probably won't achieve much, or take wigs off, or whatever is necessary. Let's see how we go, though.
I'm grateful. As my lords will have seen, this appeal concerns a patent that claims the compound dapagliflozin, which is a highly ineffective inhibitor of the enzyme SGLT2, which is used to lower blood and plasma glucose levels and thereby treat diabetes. It's been hugely beneficial to patients and commercially it's very important to AstraZeneca. And the respondents wish to sell a generic version of it. They're currently restrained by interim injunctions. And as my Lord Justice Arnold appreciates from dealing with those issues, there are a considerable number of generic companies that are very keen to sell it. Now, dapagliflozin is the only compound the subject of the patent. This isn't one of those patents that speculatively throws the net over a very wide field. And the patent explains clearly and correctly about dapagliflozin's properties and how, because of those, it's useful to treat diabetes. As I've explained, all that is correct. The issue is that because there's no data in the patent corroborating those statements, and at trial, the claimants argued that the patent was invalid for three related reasons. The first one was an earlier patent that disclosed a class of molecules that were said to be SGLT2 inhibitors. That class covered dapagliflozin, but the patent didn't disclose it. And again, that piece of prior art had no data to show the properties of those compounds. Now, the conventional obviousness case was abandoned before closing, and that was a recognition that there was no obvious reason why the skilled person would make dapagliflozin from the prior art. The second attack was because it was said the patent was not plausible. The patent didn't make a plausible statement that dapagliflozin had the properties that the patent stated it to have. And thirdly, it was argued that dapagliflozin was a mere arbitrary selection from that earlier patent. Now, the judge accepted the second and third of those reasons, and we say the judge was wrong to do so for essentially three reasons. First, because he wrongly construed the patent as not disclosing that dapagliflozin had been tested and found to have beneficial properties. Second, because he applied the legal test based upon this court's decision in Bristol-Myers and Sandoz, and we say that that decision is inconsistent with the position of the enlarged Board of Appeal of the EPO in a case called G2 of 21. And we say that as things have developed, it's clear that the approach in Bristol-Myers and Sandoz is not the approach being taken to G2 of 21. And thirdly, in relation to technical contribution, that he wrongly failed to take into account the nature of the disclosure in the prior art and the speculative nature of the prior art itself. So I'll come and deal with those points in that order. I think, my lords, having read the judgment, will understand the technical background to the appeal. Maybe I can just spend 2 or 3 minutes just giving a very potted
If only for me, that might be helpful.
So my lords, glucose is a sugar that supplies energy to nearly all the cells in the body. And the body keeps the level of glucose in tight control. Excess glucose is converted into glycogen and stored in the body, in the cells, for when it might be needed later. And the way that's done is insulin is a hormone that's produced in response to high glucose levels that starts the process of the conversion of glucose to glycogen. diabetes is a disease that's caused by excess glucose in the bloodstream. Excess blood glucose causes vascular complications that can lead to damage of the eyes, kidneys, heart, and therefore lead to blindness, renal failure, and cardiovascular disease. And my lords will be familiar with the two types of diabetes. That doesn't matter for the purposes of the appeal. Now, glucose undergoes a process of reabsorption in the kidneys, and that's mediated by sodium glucose transporters, and those are enzymes that transport glucose from the nephrons in the kidneys. So blood goes into the kidneys, contains glucose and other materials. All those materials are filtered out of the blood, but the glucose is then returned to the blood, and one of the enzymes that facilitates that return are these enzymes SGLT2, SGLT1 and 2. And any glucose that isn't reabsorbed into the blood is excreted in the urine. Now, as the judge explains, it was common general knowledge at the priority date that there were two enzymes, SGLT1 and SGLT2. SGLT2 was known to be responsible for the majority of the glucose reuptake. And so it was also known that inhibition of that enzyme would increase glucose in the urine and thereby reduce blood glucose levels. And so an important finding the judge made in the judgment in paragraph 209 was that it was common general knowledge that SGLT2 inhibitors had the potential to treat diabetes. The link between inhibition of SGLT2 and diabetes and treatment of diabetes had been made. So that is the basic biology of what's going on. One more thing to mention before we turn to the patterns. As the judge explained in 143 and 144 of the judgments, there was a compound, a naturally occurring compound called fluorescein that had been known for over 100 years. And in the 1960s, it had been demonstrated that fluorescein prevents renal glucose reabsorption. And it had been used to lower blood glucose in animal models and therefore be used as a tool to investigate the impact of high blood sugar levels on insulin secretion. But it was also known that it was not suitable to treat diabetes in humans because when taken orally, it was hydrolyzed into potentially harmful components. So with that, can we turn just to look at the patterns in question? So that's the supplemental bundle and tab 1. Now, it is correct that for the purposes of cases like this, we should be looking at the application for the patents and not the grant of patents. But as the judge noted in the judgment, once the abstract for the application is ignored, the application for the patent is identical to the patent itself, and so the parties worked from the patents at trial, and we can do the same on the appeal. So, my lords, look at the front page of the patents. It's entitled C-aryl-glucoside SGL2 inhibitors and method. And if my lords look in the right-hand column at the bottom, one sees an indication. It says remarks. The file contains technical information submitted after the application was filed and not included in this specification. So, the patent telling the reader that there was information was filed after the patent was filed, and that can be found in the European Patent Office's file.
What do you say the significance of that is?
Well, we'll come to it, because my learned friend complains that the approach that we urge in law means that things are being kept secret. He says the effect of the data not being put in this patent was that that information is being kept from the public. The relevance of that is the public knows there is data and they can go and look it up for themselves. So nothing is being kept secret.
Right, but so from your perspective, it's a negative point that there's no secrets.
Yes.
Okay.
So my lord, paragraph 1 over the page. The present invention relates to CRL glucosides, which are inhibitors of sodium-dependent glucose transporters found in the intestine and the kidney, SGLT2, and a method of treating diabetes. And then it goes on to list further indications, all related to hypoglycemia. Then in paragraph 2, the patent introduces type 2 diabetes. And we see in the last 2 lines the statement, an inhibitor of sodium-dependent glucose transporter, SGL2, in the kidney would be expected to aid the normalization of plasma glucose levels and perhaps body weight by enhancing glucose excretion. And as I've explained, that was common general knowledge, that statement. Then in paragraph 4, the patent talks about hyperglycemia being a hallmark of type 2 diabetes. And in line 26, the patent refers to this SGLT2 specific inhibitor fluorescein and closely related analogues, that they inhibit the reuptake process in diabetic rodents and dogs, resulting in the normalization of plasma glucose by promoting glucose excretion without hyperglycemic side effects. And then in the last sentence of that paragraph, selective inhibition of SGL2 in diabetic patients would be expected to normalize plasma glucose, thereby improving insulin sensitivity and delaying development of diabetic complications. So again, drawing the link between inhibition of SGL2 and treatment of diabetes, or SGL, yes. Paragraph 5, reference to the process of glucose reuptake in the kidney and the epithelial cells of the kidney. And again, last sentence of paragraph 5, inhibition of SGL2 will be predicted to reduce plasma glucose levels via enhanced glucose excretion in diabetic patients. Paragraph 7 refers to fluorescein, providing proof of concept in vivo of promoting glucose excretion, lowering fasting and plasma fed glucose levels, and promoting glucose utilization without hyperglycemic side effects. And then paragraph 8, the point that I made a moment ago, it's unattractive as an oral drug since it's hydrolyzed to its aglycone-fluortin, which does things, which inhibits other glucose transport. Now, my lords, then dropping down to the middle of page 3 of the patent, we see in paragraph 11 a reference to an earlier patent, W0128. That's the patent, the earlier patent that's the prior art in these proceedings. And at this stage, I just want to note that there's nothing said about that application in particular. It's just a standard acknowledgement of the prior art, as is common with EPA practice. Then if we go over the page, paragraph 13, it says, in accordance with the present invention, a CRL glucoside compound is provided which has the structure, and that molecule there in Formula 1, that is dapagliflozin. It's the one we're concerned about. And then importantly, paragraph 14, the compound of Formula 1 possesses activity as inhibitors of sodium-dependent glucose transporters found in the intestine and the kidney, and is useful in the treatment of diabetes and other diabetes complications. So a clear statement there of the properties of dapagliflozin, that it's the inhibitor of the sodium-dependent glucose transporters in the intestine and the kidneys, i.e. SGLT2, and that it's useful for treating diabetes.
On your case, is that any more than an assertion?
Well, yes, not at this stage, because we have to come on to look at what the patent says about the assay. But when we go through the patent, we see, for example, in paragraph 19.
Well, hold on, I'm asking you about paragraph 40.
Well, my lord, we can't.
Is that any more than an assertion on your case?
In the context of the patent as a whole, no. Because when one comes to look on at paragraph 115 of the patent, we say that the correct interpretation of that paragraph is that dapagliflozin has been tested and found to be active. So one can't just look at individual paragraphs in the patent in their isolation. One has to look at them as part of the greater whole.
But you also rely on paragraph 14 to support your argument on 115, saying because we've identified the position in paragraph 14, that assists in interpretation of paragraph 115.
Well, yes, it assists in the sense that paragraph 115, as we'll see, refers to the inhibitor as having been tested. and the only thing that's identified anywhere in the patent as the inhibitor is dapagliflozin in Formula 1. So, my lord, I'll come on just in 2 seconds to paragraph 115. All I wanted to mention was that in paragraph 19, for example, we see the term other therapeutic agents refers to one or more antidiabetics, brackets, other than SGLT2 inhibitors of Formula 1. And that formulation is referred to in a few other places. For example, on internal page 11 of the patent, in paragraph 51, 52, and 53. But then if we turn on to paragraph 115 on internal page 15, we see assay for SGLT2 activity. And the point that we make is that this paragraph describing the assay is described in the past tense. So the mRNA sequence was cloned, the sequence was stably transfected into CHO cells, its clones were assayed, and so on and so forth. And then when we get to line 34, cells were incubated with 10 micromolar AMG and 10 micromolar inhibitor, get the important word right, and so on and so forth. And then it talks about the controls, and then the very last sentence, for determination of EC50 values, 10 inhibitor concentrations were used over 2 log intervals in the appropriate response range, and triplicate plates were averaged across the plate.
So, 2 questions about that at this stage. Firstly, as I read it, we see the word inhibitor with no definite article in front of it. It doesn't say the inhibitor, it just says inhibitor. So, in that sense, it's a generic description, yes?
My lord, we say that in the context of the whole, where the patent is about a single molecule that is described as an SGLT2 inhibitor, that the skilled person would understand that reference to inhibitor as a reference to the only molecule that is being described as the inhibitor, and that's dapagliflozin. And the
go on to the second question. In line 34, we're given a concentration 10 micromolar inhibitor. In line 39, it says 10 inhibitor concentrations. Am I right in understanding that there is no teaching anywhere as to what the other concentrations are?
No, my lord. Other than they are over 2 log intervals in the appropriate response range.
Yeah, but we don't get any more than that.
No, but there is a cross reference to obviously in the next paragraph of the paper by Ryan. But my lord's right. We don't get details in the patents of the actual doses that were used.
Thank you.
And then just before we leave this, 114 above this, there's a paragraph.
Sorry, I should have followed up. You say we got the reference to Ryan, which I see. But if you look at Ryan, does the methodology match such that you can thereby determine what the 10 concentrations are?
No.
Right.
No, the methodology matches, but the precise concentrations don't. We can't get. And then, so my lord, 114, the SGLT2 inhibitor activity of the invention may be determined by use of an assay system as set out below. That's a paragraph that Ryan likes. But as we'll come on to, we say that doesn't take away from the teaching of 115 that follows it. So then finally, the claims on page 19. For the purposes of the appeal, we only need to consider claim 2, which is a claim to dapagliflozin.
Well, before we get to the claims, you have very understandably, I don't understand, please, this is not a criticism, but you have skipped over various other passages. Can I ask 2 questions about those? First of all, you left off, you didn't comment on the detailed description of the invention from 21 through to 113, apart from drawing attention to the phraseology SGL2 inhibitor of Formula 1 in paragraphs 51, 52 and 3. Do I take it, therefore, that from your perspective, there's nothing to be got out of those?
No, well, their description of the synthesis of the molecule.
No, the description of the synthesis comes later. That's going to be the subject of my second question, but I'm still on my first question at the moment.
Yes, sorry, my Lord. My Lord's right. They're a description of other drugs that can be used with it and methods of administration and so on and so forth. And no, we don't get anything out of those.
And then we come to the synthesis, which we have after the analytical method, and it's 118 and following down to 128, and again, I take it you get nothing out of that.
No, other than to note that there's no suggestion in this case that the patent doesn't enable the skilled person to make dapagliflozin.
No, it tells you precisely how to do it.
Before you go on, could I ask you a more general question? You said a moment ago with reference to I think some part of 115, but I want to get above the detail, that you say that in the context of the whole patent, the skilled person would understand such and such a thing. Doesn't matter what it is. The judge heard evidence from experts about that question. Did he not?
Yes. Well, yes, to the extent that it was relevant.
Well, that's what I want to ask you.
So my Lord,
He heard evidence about that, and there wasn't an agreement about that. Is that right?
well, my Lord, the relevance. This is a document.
Could you, but because I have to go in small steps about this,
Yes.
stay with my question. I'm trying to understand your submission, which is that you say that in the context of the whole, the skilled person would understand such and such a thing. That was an issue at trial, which was covered by expert evidence. What I want to understand is what is our role in relation to that, because obviously you wouldn't assert that simply because you say that a skilled person would understand something, therefore it is the case. What are we tasked with doing, just not with relation to any aspect of the science here, but from a legal point of view? What test are we applying to this? What are we doing when considering that assertion?
Question of the teaching of a document, such as the patents or a prior art document, is ultimately a matter for the court. It's not a matter for the experts. Expert evidence can be admissible to elucidate technical considerations relevant to its understanding, but ultimately attributing meaning or lack of meaning to the document once the context has been explained to the court is a matter for the court.
Let's take that the expert evidence is in its proper place and the decision of interpretation is a matter for the court. So what is the standard that we're meant to apply? Because the judge interpreted it and reached a conclusion which you challenge. But what are we tasked with doing? Is it to say that the judge reached a conclusion that he couldn't have reached interpreting this document? Isn't that what you have to show us, or is it something else that you have to show us?
No, well, we have to show your lordships that he was wrong.
Yes.
This isn't a decision like obviousness, where it's a multifactorial decision and the trial judge gets an ambit decision making. This is a question of construction of the document is a question of law, and it's for the court. And if my lords think the judge construed it wrongly, you can overturn him and substitute your view for his.
Right. So we look at it ourselves, you tell us, and you say that having looked at it ourselves, we reach the opposite conclusion to the judge.
Yes.
Okay, thank you.
So, my lords, I was just coming to the claims, and just briefly, I think my lords have this. For the purposes of the appeal, claim 2 is a claim to the product dapagliflozin itself, and claim 15 is a claim in what's called second medical use form or Swiss style form which is to the use of dapagliflozin for the treatment of diabetes. There's a little twiddle on that because it's dependent on Claim 14, and there was an application to amend to limit Claim 14 down to just diabetes at trial.
Well, indeed. Can we just take a very quick look at that? I know this is somewhere in here, or maybe it's the other bundle.
Next tab, my lord.
Thank you. Yeah, so that's Claim 14 as amended. Now, can you just briefly explain to us the basis for the amendment? I mean, obviously, in one sense, it's obvious in that it's a deletion, and deletions are normally pretty uncontroversial. But can we take it that the deletion was made because it was accepted that there was insufficient basis in the specification for the deleted indications?
Well, I see making an amendment doesn't need to have a reason of that nature for the amendment.
Well, you've got to put forward a reason.
Well, my lord, yes, and one usual reason is to focus the claim and so to improve the position on inventive step.
But that wouldn't be relevant here.
But my lord, no, can't draw any inference from the fact that the conditional amendment was put forward.
I thought it
Unconditional.
Unconditional.
Was
Yes.
put forward.
Yeah.
As to why that was put forward.
Right.
Certainly no
So,
relation.
so to be clear, there is no concession that there's insufficient basis in the specification to support those indications. That I understand. But do you go so far as to say that there was basis in the specification?
No, my lord, there was basis for the treatment of diabetes because of the established link between SGLT2 inhibition and diabetes. And with the unconditional amendment, that's all I need to establish that's relevant.
Right. So you don't admit it, you don't make any positive case to the contrary either.
Yeah, my lord, and the only objection to the amendment that was put forward was that it didn't cure the invalidity of the patents.
To be sure, but that has nothing to do with my question, as you appreciate.
So, my lords, then moving on to the appeal and the first three rounds of the appeal. Now, rather than, given the time constraints, rather than going through the judge's judgment on the law, let me just summarise the position in relation to the law in this jurisdiction at the moment on plausibility, both for, well, in relation to second medical use claims, so claims that are to the use of a compound for treating a particular disease. The Supreme Court in Warner-Lambert held that for those to be sufficient, it had to be plausible, or there had to be some reason for supposing that the assertion that in the patents that the drug treated the disease. So in Warner-Lambert, the drug was pregabalin, it was for treatment of neuropathic pain, and it held there had to be some real reason for supposing that the assertion was true. That could be data showing a direct effect on a metabolic mechanism involved in the disease, or it could be a priori reason. But plausibility was a characteristic of the disclosure and had to come from the patent. And then in the decision of this court in Bristol-Myers and Sandoz, this court held that the same approach applied to product claims, and that for product claims to be inventive, equally required that there be something in the specification of the patent to render it plausible that the molecule claimed had the property it was said to have. So, well, that in a nutshell is where we are. Can I just show my lords just one thing from the judge's judgment, just to deal with one point? That's paragraphs 14 to 16 of the judgment. That's Court Arnold tab 5, or wherever my lords have it. Perhaps my lords could just read those paragraphs. So, well, 2 points coming from that. The first, experimental data is not required. And secondly, a statement an experiment has been done and results obtained is to be taken at face value.
Sorry, forgive me. What does certain results were obtained mean? I mean, is it sufficient just to say results were obtained, or do you have to define what results were obtained in any way at all?
You have to explain that results have been obtained and that the particular and the nature of those results. So you can describe the results of the experiment in narrative form rather than setting out the particular numerical data of the results.
So in this case, if it had said the assay was carried out and demonstrated inhibitory behaviour or activity, you say that would be sufficient?
Yes, and we say that is properly understood.
What is to be implied or understood?
To be implied, yes. So if we can now go on to the judgment where the judge deals with this, we can pick it up at paragraph 219 of the judgment. So the judge is dealing with this by considering 3 questions that were set out in the case called Fibrogen, which is to ask, well, what is the claim to? First question, what does it mean to say that the claim works? And then finally to consider whether it's plausible from the specification that the claim does work. So 219 was straightforward. It was limited to the compound or it's used to treat diabetes. And then in 220, the judge dealt with the question of what working means in this case. And for the purposes of my appeal, we don't need to look at that. My learned friend does have a respondent's notice point on one bit of it, but obviously he'll develop that in due course. So if my lords go to 232, on page 55, internal page 55 of the judgment, the judge concludes what it means to work for the purpose of the second Fibrogen step in relation to claim 15 is treating diabetes in the sense of having sufficient efficacy to treat diabetes. And in respect of claim 2, it's either the same as claim 15 or reducing blood or plasma glucose in vivo with sufficient efficacy to allow it to be used as an experimental tool. it's that second part, the Mother and Friend challenges, but we'll pass over that for the moment.
Well, do we need to get into that? Are you relying on B? Does it help you if you fail on A?
Well, we don't see that it makes a difference.
Right.
That's not in my control.
Well, you see, it is in your control, because if you're willing to confine your case to A, we don't have to worry about B.
Well, I think I'd like to, my lord, at this stage, I think it's too early for me to make that concession.
All right, well, I understand that, but perhaps you can think about that, because reading your skeleton argument, you didn't seem to be placing any weight on B. So, give it some thought.
We will give it some thought. And so then he comes to the third Fibrogen step, and in 234 there was common ground between the experts that the mechanism proposed was a plausible one, that SGLT2 inhibition would lead to reduction of glucose. And so the question was whether the patent discloses enough to make it plausible that dapagliflozin has activity as an SGLT2 inhibitor. The judge then refers to the various paragraphs in the patent that I've shown your lordship, and then in 238 he comes to his reasoning, and the first is he relies upon paragraph 114, where it says the invention, the activity may be determined. Now, we say that, of course, can't take away from the statement in paragraph 115 that follows, that says that it was in fact done. And there's no inconsistency between the two paragraphs. The assay, of course, may be used to test the activity of the compounds, for example, if you wanted to verify it, but then it goes on to report what had been done. And the second point the judge made is the one that we've touched on already, which is that the paragraph 114 refers to 10 micromolar inhibitor. And we say this is where the judge lost sight of the nature of the skilled person. The skilled person is someone who has a mind willing to understand, not a mind desirous of misunderstanding. And as I've already submitted, where the patent is about a single inhibitor molecule, to conclude that the skilled person would think that the reference to 10 micromolar inhibitor in that assay, as having reported as being tested, was something other than a reference to the SGLT2 inhibitor of Formula 1, is turning the skilled person into an extreme skeptic and someone who engages in speculations of all the things that possibly might have happened, rather than someone who simply considers the ordinary and natural meaning of the document. Now, in 239, the judge then referred to the cross-examination of Professor Bailey, and we say he was wrong to draw any conclusions from that for a few reasons. The first one is that, as I've explained, construction of the document is a matter for the judge, not for the witness, and the witnesses are there to give technical context, not to tell the judge what it means. Second, of course...
Where is the vice in the judge's reasoning on that score?
Well, my lord, it's...
When he says he's accepting the submission.
Yes, well, my lord, I'll clearly...
And making reference to the witness evidence. What's objectionable about that?
Well, let me show... So the point he accepts...
Not as to the detail, but what is the... Just in a sentence I can...
Well,
write it down.
The evidence didn't support the suggestion that the skilled person would think that only things other than dapagliflozin had been tested, and that was never.
Well, I thought the point that you were launching on at the moment was that it was a matter for the judge and not for the witness, and so I'm obviously searching for an instance where the judge has thought it was a matter for the witness and not for the judge.
Well, because what the judge has done is he's relied upon cross-examination of Professor Bailey to conclude...
Yes, my question to you, because I'm coming back to what we discussed earlier on, is what is objectionable about that as a method?
Well, he's allowed to understand. He's allowed to understand the context of the patent from the witness.
Yes,
but
I can perfectly understand a submission which says the witness was wrong and the judge was wrong to rely on the witness. but I'm not at the moment understanding a submission which says that the method whereby a judge reaches a conclusion having regard to what a witness has said is in any way objectionable. Is this a freestanding objection?
No, perhaps, my lord, it's more related to what I'm coming on to, which is
Well,
that the witness, the evidence didn't support it being that the skilled person thinking it would be the only thing that had been tested. So, on this, first of all, this was not a point that any of the respondents' witnesses made. So none of the claimants' witnesses suggested that the skilled person would think things other than dapagliflozin had been tested. And if it had been a good point, one would have expected them to say it. It was a new point put to Professor Bailey in cross-examination by Mr. Mitchison. The cross-examination was in two...
So, I'm struggling to follow the thread of this. So, is that an objection that somehow that question was inadmissible? Because if so, you would have made that objection then and there, then the judge would have ruled upon it.
No, my lord, it's the context to it. That the only evidence on this came out of cross-examination. I just want to show you, my lords, the two passages of that cross-examination, because my lords can see what happened. So we need to go to the supplemental bundle in tab 17. And we can see on internal page 500.
Just before we get into the details, so your objection is not a procedural one. Your objection is a substantive one, and like my lord, I just want to be clear what the objection is before we get into the details. So I'm inferring from what you've said so far that you're about to make a submission that the judge's finding as to the evidence is not supported by the evidence. But at the moment, that doesn't seem to me to be a ground of appeal.
Covered by yes, my lord, it's paragraph 4, underground 1. One ought to reply the expert evidence which you referred to resolve as properly a documentary interpretation for the court.
But that's a submission that it's inadmissible. In which case, we don't need to look at the transcript, because you're either right or wrong. It's either admissible or it's not admissible. Whereas we only need to look at the transcript if you're going to submit the judge was wrong as to his finding as to the evidence.
Yes, and I am submitting that he was wrong as to the findings.
So where is that in the ground?
Well, it's covered by the generality of what the judge should have found in 3.
All right. Well, let's see what you want to rely on.
So, my internal page 550 on 275 of the bundle. We can see Mr. Mitchison starting on the prior arts. All I want to do is just give my lord the signpost at this stage. Then if we turn over the page to 277 and internal 558, he goes on to look at the assay down in line 21. And then over to internal page 561, he says at line 12, you and Professor Potter have agreed that the assay would need to be validated before the selection criteria could be established. And there's then some confusion as to whether he really meant Professor Potter. And at line 25, you and he agree the pharmacologist and medicinal chemist would validate or develop a simple screening assay to be used. Yes, that would be standard procedure. And then down at line 21, 22, certainly at this stage when validating an assay, you want a fairly easy target just to make sure you can work it, and he agrees with that. And then over in 563, Mr. Mitchison puts some questions and gives some examples such as fluorescein or the Tanabe compound T1095. So at this stage, all that's been established is when you set up your assay, you want to make sure it works and you use some things that you know will work. So then he moves on to the patent itself.
Well, you've missed where it's put that the obvious one to use would be fluorescein.
No, sorry, well, I thought I'd said that.
Right. Okay.
Fluorescein
This is my fault.
Fluorescein and the Tanabe compounds were the examples given. Then over to internal 611. Page 2 now of the bundle. And at line 5, Mr. Mitchison says, just looking at SGLT2 inhibition, you accept there's nothing technical in the 6 pages you've picked out. Yes, that's right. So he says there's no scientific rationale for any of the bare statements. And then the witness says there's an assay, and I presume that we have a compound, it's been synthesized, there were 20 grams of it. We know some tests have been undertaken. There's only one molecule, so presumably it's going to have been tested. And then he goes on to note that there haven't been any data. And then if we drop down to 612, line 5, there's no results of any assay, and the patent doesn't give you any results. And then the explanation you've just given me, the only thing you could put your finger on the assumption is that it's been tested. It had in fact been tested in the assay. It says it was, so I assume it says it was. And he says, Professor, the patent never says the molecule has been tested in the assay. The assay was performed, so I've just taken the assumption, if you like, that it says it's been done, it's been done. I have no reason to believe it was not. And then Mr. Mitchison says, we've discussed there are a number of other things that could have been tested in the process of validating it. Yes. You just do not know what's been tested in the assay, Professor. You are correct, I don't know what's been tested. Yes. And then he goes on to talk about levels of inhibition. So it's clear that Professor Bailey thought that the skilled person would think dapagliflozin had been tested. He expressed that very clearly in that passage. And all my learned friend slipped in at the end was that other things could have been tested in the process of validating, to which the witness said yes, because that could have happened when it was validated. And that's obviously perfectly consistent with the view that dapagliflozin had been tested and other things had as well. My learned friend never put to Professor Bailey that only other things had been tested. And therefore the judge was reading too much into that passage to conclude that it was an acceptance that only other things had been tested. Now, my other friend's got a couple of more detailed points on the evidence, but I think given the time I'll let him develop those and deal with them in reply insofar as I need to. All I would say is that he has a suggestion that it was never even put to his witness that dapagliflozin was tested. But when he shows you that passage of evidence, you'll see actually that it's very clear that Miss Lane did put that. So overall, my lord, we say that the judge should have held, given the teaching of the patent and given that evidence that I've shown you, that the skilled person would have understood that paragraph 115 and the rest of the disclosure of the patent describing the properties of dapagliflozin was a narrative description of an assay that had been done. Now, the second part of the judge's judgment deals with what's been called the levels point, which is the judge made an additional point that the specification didn't make it plausible that the efficacy had found to be of a sufficient potency that it would be understood to be useful for treating diabetes. Now, it's important at this stage to know that the evidence, the judge's finding as to common general knowledge in paragraph 214. I might also go back to that. So, Core Tab 5, paragraph 214. So in 214, the judge recorded that neither party suggested that the skilled person would have been aware of the degree of SGLT2 inhibition that would be needed to affect blood or plasma glucose levels. So this wasn't a case where the skilled person had a known cutoff. And in paragraph 218, goes into that one, the judge made a number of findings. So he said there's nothing in the CGK about SGLT inhibitors to alter the general position as to potency requirements that he'd set out in 110 above. And then in the 6 lines down, they would recognise the compound with millimolar EC50 would not be credible. But the lower the EC50, the more likely it was that the compound would have sufficient efficacy in vivo. Ideally, a compound for treating diabetes would have low nanomolar EC50, but the skilled person would recognise that a compound with high nanomolar might prove to be useful. And doing the best he could, he agreed that it would be something similar to fluorescein would be useful for an experimental tool. So overall, the skilled person didn't, as a matter of common general knowledge, have a known target that they were shooting for. And then when we come on to the judge's judgment in relation to this issue in paragraph 255, we're back to page 60. The judge rejects our submission that the skilled person would have understood the teaching of the patents, and particularly the statements that dapagliflozin was useful for treating diabetes, as being bootstraps. And we say that he was wrong to do that. It's not a bootstraps argument. It's a point based on the teaching of the document. And the skilled person sees from the document that dapagliflozin is an inhibitor of SGLT2. But further, it is useful for reducing blood glucose. And the skilled person would understand from that it has sufficient activity for that purpose. Now, the judge in 256, as my lords can see, looked at 2 passages of the cross-examination of Professor Bailey, and 2 things to note about that. Firstly, they are 2 separate passages, and the first part, down to it could be one you know would not choose to carry forward, all that cross-examination was in the context of the prior art. So none of that relates to dapagliflozin itself. And so we say that's simply not relevant for the skilled person's understanding of what the patent itself teaches.
Sorry, is the submission that the assay under discussion is different?
Well, it's the same text in the patent.
And
but
therefore the same assay?
In the same assay. But when we look at when you look at the answer that you would not be able to derive potency from the information given here correct, that's an answer that's given in the context of the prior art. There's no consideration of dapagliflozin.
The text is the same, you accept. So why is it different?
Well, because it's a document that's about a much wider class of molecules rather than dapagliflozin. There's a patent which is to a single molecule.
Right, so what's the difference in the text that allows you to derive potency in the patent that's absent in the prior art?
Well, because the prior art is about very large classes of molecules, and the skilled person looking at that document would not think it was plausible that all those molecules have been tested and found to be active. Whereas
so that sounds like a submission about plausibility rather than the text of a document.
Well, it's about the understanding. The skilled person wouldn't understand, looking at a statement made about a class, even the narrowest class that was common ground to cover many millions of compounds, that statement related to each and every one of them. Whereas it's very different when you're looking at a statement that relates to a single molecule.
I'm sure it's my fault, but I'm not following this, because at the moment this seems to me to be evidence about the information you get out of the assay, and you accept assay described is the same, described in the same words. So how do you get more information as to potency when the same words are in the patent than you get out of those words when they're in the prior art?
Because the skilled person wouldn't think that that statement was being made about every single molecule in the classes of the prior art, whereby when you've only got a single compound in the patent, there's no reason to think that that hadn't been done in relation to that single molecule, and that's what the understanding would be.
There's no reason to think that the assay has been done on every single one of the hundreds of thousands of compounds. But why wouldn't the person reading it in the prior art say that sufficient assays have been done for the claim to be made that all of these compounds would behave in the same way?
Well, when we get to it, we say that they wouldn't think that. They would, from the prior art, my lord's jumping ahead to the last ground of appeal, is because there are so many compounds falling within the scope of the claim, it wouldn't be understood that each and every one of those has the relevant activity. But going back to the second part of the evidence here, which was in the context of the patent, and actually picks up from the paragraph that we were just looking at about other compounds, all that establishes, my learned friend put up the point, there's even less to tell you that dapagliflozin is effective an SGLT2 inhibitor at levels that provide any utility to treat diabetes or otherwise. We do not know the level, yes, or the potency. We do not know how effective it needs to be. We probably do not at this stage. So that's just a confirmation, or just a consequence of the fact that there is no data in the patent, and, as I showed you, that the skilled person doesn't have, no matter their common general knowledge, a clear cut-off for how active the drug needs to be. But we say that doesn't take away from the fact that there is clear statements that the activity, that the compound has been tested, it's been found to be an inhibitor of the enzyme, and it is suitable for treating diabetes, and therefore it would be understood that the activity has been found to be sufficient to treat diabetes. So I was just wrapping up on the first three grounds in the light of those two errors of understanding the document. We say had the judge understood it properly, then it would have been, then the patent can be seen to be plausible and be a plausible disclosure of the efficacy of dapagliflozin, both to treat diabetes and as the experimental tool. So unless my lords have any questions on that aspect of the appeal, I was going to move on to the second aspect, which is the issue of law.
Yeah. I'm beginning to think that given the situation with which you're contending generally, at some point, maybe in half an hour or so, when you find it convenient, we'll have a short break, if that would suit.
Thank you. Well, if I don't do it, someone will probably, or my lord will shout.
I'm sure somebody will. I'm very sorry about this. There's really nothing we can do about it.
My lord, if my lords are struggling to hear me, just tell me to shout.
Well, also we have the benefit also of the very good transcription. I don't suppose it matters at all, but the microphone is obviously having difficulty in distinguishing between my lord and myself. So a lot of very good points that are being made from my left are being attributed to me. It can be corrected if it's really necessary, but I'm just making that disclaimer.
So, my lord, coming on to the second part of the appeal, and as my lords will have seen from our skeleton, we say that the decision of this court in the apixaban litigation, Sandoz and Bristol-Myers, can be seen to be inconsistent with the decision of the enlarged Board of Appeal in G2 of 21, and in particular in the way that that's been applied subsequently by the EPO and national courts. And therefore, under the extra part of the Bristol aeroplane test set out by this court in Activist and Merck, we say that my lords now can and should not follow the decision in Apixaban and follow the established law of the EPO in relation to it. Now, the key point for this part of the appeal is harmonisation. And patent law in this country comes directly. The Patents Act 1977 is expressly framed to implement in this jurisdiction the European Patent Convention. And courts in this country, including the House of Lords and the Supreme Court, have repeatedly stressed the need to harmonise our patent law, both with courts of EPC member states, but also the European Patent Office. And many cases could illustrate this point, but perhaps I can take my lords to Eli Lilly and HGS, which is in the first volume of the authorities. At tab 7, and if we can go to bundle page 85, sorry. So in paragraph 83, under the heading following the board's jurisprudence, and the board here actually means technical board, it refers to the fact that firstly, when the EPO upholds a patent, it's still possible for national courts to decide that the patent is in fact invalid. But then 4 lines from the bottom, in all cases, the EPO and each national court are of course applying the principles contained in the EPC. It's plainly appropriate in principle, highly desirable in practice, that all these tribunals interpret the provisions in the same way. And they refer to a number of decisions of the House of Lords drawing importance to that. And then if we go on to paragraph 87 on the next page, and they say, while national courts should normally follow the established jurisprudence of the EPO, it doesn't mean that we should regard the reasoning in each decision of the board, and that's the technical board of appeal, as binding on us. There will be no doubt some decisions where the court considers it may take the law in an inappropriate direction, misapplies previous jurisprudence, and so on. And then a few lines down, nonetheless, when the board has adopted a consistent approach to an issue in a number of decisions, it will require very unusual facts to justify a national court not following that approach. And then in 88, they say there's been little helpful domestic guidance as to Article 57 of the EPC, but there have been a number of decisions of the board that have addressed the topic, and we've ought to adopt a consistent approach. And it's true there's been no decision of the enlarged board on the incident point. Now, my Lord Justice Arnold knows this, but for the rest of the court, the European Patent Office is the central granting body that grants European patents. It generates law largely as through the process of opposition, whereby any party can challenge the grant of a patent after when it's granted. There is a first instance opposition division. There is an appeal as of right to the technical board of appeal, and then exceptionally, on a point of law, there can be further appeals to the enlarged board of appeal. Now, as we saw, well, the EPO doesn't have a system of precedent like we do in this jurisdiction, and so as we saw in Eli Lilly and HGS, you can get stray rogue decisions. But there are 2 circumstances when this court should follow the approach of the European Patent Office. The first one, as we saw, was when there's a consistent line of technical board of appeal decisions. And the second way is if there's an enlarged board of appeal decision on the point. Because, as we said in our skeleton, Article 112 of the EPC expressly sets out the purposes of a reference to the enlarged board, and that's first to ensure uniform application of the law, or second, when there are 2 conflicting decisions from 2 boards of appeal. So, by its nature, a decision of the enlarged board settles the law in the EPO. And as my Lord Justice Arnold will know, in the last week or so there's been a decision on claim construction coming down that was given for precisely that reason. So, but importantly, going back to harmonisation, harmonisation does not mean merely aligning ourselves with the EPO and other national courts in how they apply the European Pact Convention only when we agree with it. It also involves us doing so when the courts of this jurisdiction might have thought a different approach was better. And if my lords go back to tab 2 in the authorities bundle, you should still have open. I can show you an example of that, which is a case called John Wyeth's application from 1985, and this was the Patents Court sitting on banc, Justice Whitford and Faulkner, and if my lords go to page 565 of the judgment,
Five six five.
565 of the judgment, so it's page 87 of the bundle.
Thank you.
This was, the background was, this was the Patents Court considering for the first time Swiss-style claims, so second medical use claims, which we've referred to already. These are claims that allow a known substance to be patented for a new use. And we see at line 13, however, that stated, had the matter to be considered on the wording of the sections of the Act, and without regard to the position as it has developed under the EPC, we think the better view will be the claims in the Swiss form to an invention directed to the use of a known pharmaceutical to manufacture a medicament, not in itself novel, for a second or subsequent novel purpose, would not be patentable as lacking the required novelty. So, Whitford J and Faulkner J think that they shouldn't be allowed. They then go on at the very bottom of the page to refer to a decision of the enlarged board, and that's the decision in the case, in the Assay case, G5 of 83. And we don't need to look at the reasoning of the board going over that page and over to page 567 of the judgment. But if my lords perhaps can just read the paragraph line 27 to yourselves.
That approach.
Yes. So they didn't agree with this, but for the sake of harmonisation, they decided that they were going to follow along. And we've had those kind of claims in our law ever since. So harmonisation obviously is a good thing, not just because the Act is expressly drafted to implement and have the same effect as the European Pact Convention, and because the House of Lords and the Supreme Court have said that we should, but obviously also it's good for business and industry in general. Many industries, the pharmaceutical industry in particular, are ones that operate across the whole of Europe, and consistent application of the law is good for business, and inconsistent application is not. So with that, my lords, can I turn to the decision in G2 of 21? So my lords can put the first volume of the authorities away and get the second one out. Oh, and tab 20, sorry. So this is my lords then turn over the page to page 1083 of the bundle. We can see at the bottom there was a very large number of enlarged board and technical board cases were cited in this case, and then we'll keep flicking over. There were many decisions of national courts, literature considered, and so on and so forth. And if we go to bundle page 1090, we can see the question that had been referred to the enlarged board, and that's the question in italics. there. And if I can just summarise what they were asked. So they were asked for acknowledgement of a preventive step. If for acknowledgement of a preventive step, a patent proprietor relies on a technical effect and has submitted evidence such as experimental data to prove such effect, this effect having not been public before the filing date. And the first question was, should he be allowed to rely upon that at all, or should there be a blanket cut-off that if it came after the date of filing of the patent, it was irrelevant? And if he was allowed to rely upon it, what were the criteria for doing that? And the first one was, is he only allowed to do that if the skilled person reading the patents would consider the effect plausible? And that's what they referred to as ab initio plausibility. And the second one was whether the skilled person at the date would have seen no reason to consider the effect implausible. And that's what they refer to as ab initio implausibility. And the reason why those two tests have been identified in the questions referred was there were two lines of cases in the EPO, some of which appear to apply an ab initio plausibility test, which is saying, is there something in the document that makes you think it will work? Whereas some of them were applying an ab initio implausibility test, where they were saying, well, is there any reason why the skilled person would think it was implausible? And they were using that as the gateway to looking at the post-final data. So, the first question we don't need to spend much time on, but if my lords turn to page 1126 of the bundle.
Did you say 1136?
26, sorry.
26, thank you.
This having gone through the issue of whether there should be a firm cut-off on time and limiting what they refer to as the free evaluation of evidence. In paragraph 56, they say evidence submitted by the patent applicant or proprietor to prove a technical effect may not be disregarded solely on the basis that such evidence on which the effect rests has not been public before the filing date. So they that's the answer to the first question.
Well, one of the issues is whether it is actually an answer to the question.
But then what they then go on to say is, as is their role, they were going to give some guidance as the criteria to be applied, the criteria that were required when one was looking at whether a patentee could do that. And that's effectively addressing the second and third questions. And we see that in paragraph 59. As suggested by the parties and the President, the Board acknowledges the need to provide guidance on the application of the principle of free evaluation of evidence in respect of such post-published evidence. So then at 60, they refer to a decision T578 of 06, which is a case called Ibsen, where the Board of Appeal stated that the EPC required no experimental proof of patentability and considered the disclosure of experimental data or results in the application as filed was not always required to establish the claim subject matter solve the objective technical problem. So there's no need to prove or have experimental proof in a patent to show the problem has been solved. And the Board of Appeal, we see over the page, emphasised that plausible reliance on a reported technical effect is only relevant when examining an inventive step if the case in hand allows the substantiation of doubts about the suitability of the claimed invention to solve the technical problem. So that's effectively saying only if the skilled person thinks it's implausible that the patent solves the problem is there going to be a requirement for data to show that it is. And what the board then went on to do was to look at the strands of case law. So starting at paragraph 64, they introduce the strands, and the referring Technical Board of Appeal had referred to the ab initio plausibility cases as what they call type 1 case law, and we see the decisions on that starting at paragraph 66. And an example given of a type 1 ab initio plausibility case law is decision 1329 of 04, my lord, that's Johns Hopkins, a case that's relatively well known. In that case, the board didn't allow post-published evidence to be taken into account and denied there was an inventive step with the claimed subject matter because the application as originally filed lacked enough evidence to make it at least plausible that a solution had been found. But perhaps if my lords can just read the quote from the judgment at the bottom of that page and over onto the next page, and then I'll just make an observation about that. And so the molecule in question, GDF9, was said to be a member of something called the TGF-beta superfamily. But as the board noted, its structure was significantly different from other members of the TGF superfamily. And so they held that because of those differences, it effectively wasn't plausible that the molecule in question had the same properties, and therefore they denied them the ability to rely upon post-file data to prove that. And the paragraph then goes through and looks at other cases to a similar effect, which we don't need to look at the details of. But if we turn over to paragraph 69 on page 1135, the board then looked at what they had referred to them as type 2 case law, which is the case law where the question was, would you have seen any reason to consider the effect implausible? And at the top of page 48 of the judgment, they refer to T536 of 07. And just to give my lords an example of one of these cases, the technical board had said, although there's no working examples for the claimed subject matter in the contested patents, it's not disclosed as a preferred embodiment, there is a priori no reason for the skilled person to consider it not to be plausible solution to the above-mentioned technical problem. And then a little later, just by the first hole punch, in the present case, there's no indication whatsoever of possible prejudice in the art or foreseen difficulties in carrying out the proposed solution. So although there was no worked examples and nothing to show that it in fact worked, because there was no reason to think that it didn't, that was okay. And similarly, if we go over to page 50 of the judgment, in T184 of 16, which coincidentally relates to other SGLT2 inhibitors, it says, in the present case, the application as filed does not contain any experimental evidence as regards the disputed plausibility, i.e. the plausibility of claimed compounds being SGLT2 inhibitors. It's thus necessary to determine whether plausibility can nevertheless be established in view of the common general knowledge of the prior art. The board has no indication, nor has the appellant argued, that there exists any, and that there is prima facie serious doubt that the claimed therapeutic effect can be obtained. Furthermore, there's no a priori reason or any indication in the common general knowledge that the claimed therapeutic effect cannot be obtained. So again, clearly no data, but no reason to think that it doesn't happen. So, the enlarged board then, if we go on to page 1139, in paragraph 71, they say, 3 lines down, the enlarged board understands from the case law of the Boards of Appeal as common ground that the core issue rests with the question of what the skilled person with the common general knowledge in mind understands at the filing date from the application as originally filed as the technical teaching of the invention. And then in the next paragraph they say, applying this understanding, the enlarged board is satisfied that the outcome of each of the cases would not have been different from the actual finding of the respective boards. Irrespective of the terminology of plausibility, the cited decisions appear to show that the particular Board of Appeal focused on the question of whether or not the technical effect relied upon by the patent applicant was derivable for the person skilled in the art from the technical teaching of the application. Now,
Well, that rather bore out something that I was thinking to myself, which is that the line between whether something is, whether it's plausible that something has an effect, or whether it's implausible that it has an effect, may in many cases be extremely narrow.
well, it may be, yes.
And I appreciate it's important that the right test is applied, but they seem to have, what I've understood you to be taking us to, reached the conclusion that after looking at many decisions which have applied different tests, that it wouldn't have made any difference.
No. And so what we're coming to see is they then reformulate the test in a different way without using the word plausible or implausible. But my lord is right. But of course, there is a line. There is a small area between plausibility and implausibility, which is well, there's no reason to think that it
Either
won't.
way.
Either way. So now my learned friend says this shows that they aren't trying to change the law, and I don't accept that, because as we'll come on to, what they do is formulate the test in a different way, and merely saying that the outcome would have been the same is not the same as saying we're not changing the law. Maybe that's a pedantic point, but there we go. They then in 73 go to look at the questions of insufficiency. Now, insufficiency is whether the patent enables the invention to be put into effect. And again, we come back to second medical use claims to use of a known drug for treating a new disease. And what the consistent approach of the European Patent Office has been is that because achievement of the treatment of the disease is a feature of the claim, in order to be sufficient, the patent has to make it credible that that effect is in fact achieved, and therefore there has to be something in the patent application to make it plausible. We see that over the page on top of page 53 of the decision. They say, hence, because the subject matter of a second medical use claim is commonly limited to a known therapeutic agent for use in a new therapeutic application, it's necessary that the patent at the date of its filing renders it credible that the known agent, i.e. the product, is suitable for the claimed therapeutic effect. And they refer to a previous enlarged board decision. And then they go on to review a number of decisions all to that effect. And just pausing there, of course, what that means is the decision of the Supreme Court in the Warner-Lambert case, which was concerned with second medical use claims, is on all fours with the approach in the European Patent Office. Now, if we go then to paragraph 77 on page 59 of the judgment, and perhaps my lords could just read that to yourselves.
Yes.
So what the enlarged board are saying there is that the decisions they've looked at make it clear that for the sufficiency of disclosure of second medical use claims, the ability to rely upon post-file data is more limited, because you've had to make it plausible in the specification that the effect exists. But in contrast, there's much more freedom to do so for inventive step under Article 56 of the European Patent Convention. And so we say what this paragraph is emphasising is that the approach to sufficiency, and sufficiency of second medical use claims in particular, is not the same as for inventive step more generally, and for sufficiency, it's more narrow.
Can you just help me at this point to what extent that difference is relevant in our case, given that you are faced with attacks on both grounds? So lack of inventive step is relied on, lack of sufficiency is relied on. So does it help you to get home on inventive step if you fail on sufficiency?
Yes, my lord, because we accept that if we don't win on grounds 1 to 3, as I've done already, but we do persuade your lordships on this ground, that we can't support claim 15. So we're claim 2 only by that stage. Now, claim 2 is a product claim, and for sufficiency of a product claim, the only requirement is that you can make it. And that's not in dispute. So the issue for claim 2 as a product claim is, does it have a technical, what is its technical effect? And can we rely upon the post-filed data to establish that dapagliflozin is an SGLT2 inhibitor and does treat diabetes?
Thank you.
And my lord, we quoted from the guidelines in our.
Why should you be subject to a less lenient test for a broader claim than a narrower?
Well, so my learned friend threw this gauntlet down, and I was just coming onto this now. So the reasons why it's different are as follows. The achievement of a therapeutic effect in a second medical use claim is a functional feature of the claim, and therefore putting it into effect requires a demonstration that that effect is achieved. Now, for compound cases, where the invention is just the molecule, all the technical effect is what justifies the inventive step. Second, as the Supreme Court noted in Warner-Lambert, second medical use claims are particularly susceptible to abusive speculative claiming, whereby a patent could list out a whole range of disorders, all disorders known to man, and list and say this compound may treat all these. Third, by their nature, second medical use claims are a new use of a known compound, and the invention lies in the discovery of a hitherto unknown use for it. And in those circumstances, because the new use is the only thing that distinguishes patent from the prior art, it's right that you should be made plausible in the specification. But in contrast with a new molecule, the invention is the molecule itself.
Well, is it?
Well,
are you disputing that it's not inventive simply to identify a new molecule? Because I don't find that anywhere in your grounds of appeal.
Coming on, no, my lord, let me finish my submission. The invention, what is claimed, is the molecule itself. What distinguishes it from the prior art is its structure. But it's long been recognised that a molecule absent any properties has no inventive step. And we accept that a new molecule to be patentable has to have useful properties. But our position is that doesn't have to be proven in the specification.
So the argument seems to be circular.
No, my lord, it's not. So it's ultimately, and also do we have to have a different standard? G2 of 21 is not about allowing patents to be granted for which there is no demonstration that the claim solves the technical problem or has the technical effect. It's all about when you can rely upon post-file data to prove that it does. And if you don't have, if you aren't able...
Yes, I'm sorry to interrupt, Mr. Mitchell, if you're drifting back off the question. I mean, you're making there a submission about GT21, I understand that. But what you were doing before that was making a more general submission as to the distinction in this context between inventive step and sufficiency, and giving some reasons to support your submission on that. and you were drawing a distinction between second medical use claims and product claims. And the question I first put to you was why one should have more stringent requirements for narrower claims than for broader claims, when one might have thought that it would be the other way around. The broader the claim, more justification for that breadth one would have thought one ought to have. Then specifically in this context, you made the point that the justification for a second medical use claim is the new use. And what I was asking about was, well, is that really a distinction? If you accept, as you've made clear that you do, that it's not inventive simply to identify a new molecule. What is inventive is identifying the properties of that molecule.
Yes, and of course.
So what's the difference?
Well, the difference is whether demonstration of the technical effect has to be in the specification. Two situations my Lord's putting to you. I know I'm answering questions of points of principle, but to illustrate it with the facts of this case, the patent clearly tells the reader that dapagliflozin is an SGLT2 inhibitor and treats diabetes. What it doesn't do is corroborate that with data. Now, my Lord says, what was the justification for applying a different test? And to be clear, the difference is not that. We're not urging a test that does not require it to be demonstrated that the molecule has the particular property and solves the technical effect. The only distinction we're submitting between insufficiency and obviousness is whether that corroboration has to be in the specification or not. And we've seen from the board's decision that it doesn't have to be. And the reason for that, and the reason why that's justified, is because there is, as the enlarged board said, no requirement that you need experimental proof of the benefit in the patent. And the patentee is able to reformulate.
Can I ask you this question? What's the logic? Because if one goes back to the starting point is the first to file system. So the first person to get their application to the patent office somewhere in the world gets the patent. And that date is crucial. And to maintain the security of that date, we have the requirement for priority. You can only get priority for the same invention. And even after application, we have the prohibition on adding matter. So if you're the applicant for the patent, you cannot improve your position by adding data to the specification post the filing date, because that would be contravening the rules on priority and on added matter. So if you can't improve your position by putting data into the patent application as an applicant, why should you be able to improve your position by relying on data subsequent to the patent, which isn't even in it?
Well, I mean, my Lord and I could have a philosophical discussion about these matters.
This is not a philosophical discussion, Mr. Hinchcliffe. It's a question of what's the logic.
My Lord, but so the submission I was about to make is we could have a legal debate about this, but ultimately our submission is based on harmonisation. And as I said,
so your submission is we must harmonise even if it's illogical.
Yes.
Same as Wyatt.
Same as Wyatt. So, and I'll say it now because when I come on to Bristol-Myers, you know, we don't say that the decision in Bristol-Myers was nothing other than a cogent first principles decision. But it's the fact that what we can see is that leaves us out on a limb compared to the EPO and the other European jurisdictions, and therefore to continue to apply it means we're not harmonised, and harmonisation is important, and that's why we should apply it.
That'd be a good moment for a break.
Well, it is.
We'll rise for 5 minutes. We'll go straight back. Thank you.
No, I thought not.
My days has not got any bad doors.
Transcribers, are they?
Just emailed Sam, booked up for transcription, but screw years. It's on here.
Wow. You did when you were weak,
No, it's fine.
No, that's enough. Oh, sorry.
Don't worry, well, I can join the club.
Can I just have one of those mornings? Through all, pouring water all over the bench, thank you.
Tom's always cool. You actually want this one? What do you think? I've got my previous meeting.
Well, I am at halfway to.
Yeah, no, I think we're doing right each other, thinking of it. I can just put in the old fish, but then it's see roughly how far. Wrong, I don't believe it, so I'm not doing it.
Noticed it.
Not cool out there if you want to go.
Who is it? That's just for coming. I've got a fan.
It's grim, isn't it? 30 seconds.
I don't want to unplug it because I don't lose it. As far as possible.
We seem to have a more limited crew. Shall I press on or?
No, let's give everybody a moment to regather.
Whilst we're waiting, my lords could turn to page, paragraph 88 on page 1153. Apologies for that. So can we look at the concluding considerations in paragraph 88? So that's on page 1153. And so in we look then, we can jump straight to 91. The 91, they say, evidence submitted by a patent applicant or proprietor to prove a purported technical effect may not be disregarded solely on the ground that such evidence on which the effect relates had not been public from the priority date. So that's the first question. You can't just rule it out on a pure time basis. 92, the term plausibility that's found in the case law, relied upon by the Boards of Appeal, does not amount to a distinctive legal concept or a specific patent requirement under the EPC, included under Article 56 and 83. But it's a generic catchword seized in the jurisprudence of the boards and by some national courts of the European patent system. And then they go on to say the relevant standard for reliance on the purported technical effect when assessing whether or not the claim subject matter involves an inventive step concerns the question of what the skilled person with the common general knowledge would understand that the filing date from the application is filed as the technical teaching of the claimed invention. The technical effect relied upon, even at a later stage, and I emphasise that now because I'll come back to it, needs to be encompassed by that technical teaching and to embody the same invention, because such an effect doesn't change the nature of the claimed invention. So, perhaps in answer to my Lord Justice Arnold's question just before the break, the enlarged board are keen to ensure that their decision, they say, has the overall effect of it mustn't change the nature of the claimed invention, but you can rely upon the technical effect at a later stage, provided we have that two-limb test, which we can...
Well, surely the words at a later stage relate to the words relied on.
Yes. Yes, so you're relying upon the technical effect at a later stage, not at...
They're not saying you can rely upon a new technical effect later.
Well, a patentee is able to reformulate the technical effect that they rely upon, and they can rely upon a technical effect if, and perhaps we can just turn over the page to the order because we can see where they've set it out. The set effect in number 2 on page 1156 has to be encompassed by the technical teaching and embodied by the same originally disclosed invention.
And how can you do that if the data to support the technical effect is neither in the patent nor in the common general knowledge?
Well, I'm going to come on to that in a moment. So, what does it mean? So, limb 1, is it encompassed by the technical teaching? What we say that means is the effect relied upon taught or derivable from the documents? So we don't well, I'm told the transcript has stopped. Shall I just press on and we can...
Yeah,
we'll do
the transcribers will catch up.
So we don't say it's a strict disclosure test. It does allow the skilled person to derive a technical effect from what the patent does say. But just jumping forward to the facts for a moment here, of course, in this case, it doesn't matter because our patent expressly teaches the relevant effect, which is SGLT2 inhibition and sugar diabetes. Limb 2 is the effect embodied by the same originally disclosed invention. What that is asking is, would it be understood that the claimed invention had that technical effect? Now, the enlarged board don't say in detail how that is to be assessed. They leave that up to the lower courts to implement. But we say it's clear, then it must be ab initio implausibility or something akin to that. And we say that for 5 reasons. The first is what we saw in paragraph 60, when at the very start of their discussion on this, the enlarged board started by saying that there didn't need to be any proof of a technical effect in the patent specification, relying upon the Ipsen case. Second, the paragraph in paragraph 93, where they say the technical effect relied upon at a later stage. And what's implicit in that is that you're relying upon something after the patent was filed. And of course, if there was a requirement that the technical effect had to be demonstrated in the specification itself, then you wouldn't need to rely on it at a later stage because it would already be there. Third, there's the distinction that was drawn in paragraph 77 with insufficiency, where they make it clear that although the test for insufficiency is ab initio plausibility, there has to be something in the specification to make it credible. There is the threshold for relying upon an effect for inventive step is lower and not the same. And what is clear is they don't express the test for inventive step using the same words as they do for sufficiency. Had they wanted to say test is the same, it has to be made plausible by the specification, then they could have written that very clearly in the order, but they didn't do that. But perhaps most importantly, we say the only way that you can reconcile the endorsement of the results of the ab initio implausibility cases that were referred to and the ab initio plausibility cases is if at this stage the test they're applying is ab initio implausibility or akin to it.
It's levelling down.
Levelling down. Because otherwise you can't reconcile a case like the one we looked at where there's actually was referred to the SGLT2 inhibition itself, where there was no data in the specification. It said the compounds were inhibitors, and still they said the result would be the same. Now,
I've written down 4 reasons. You said you had 5.
yes, I was just thinking where I was going to make the 5th one, actually, my lord. But
Right.
let me say it, my lord, and my lord may shoot it down. It's that in the preliminary communication from the enlarged board, they set out exactly the same test as in paragraph 93, but they expressed it expressly in terms of ab initio implausibility. Now, I accept, and the reason why I did it on it, my lord, is because it's a bit one of those double-edged points, because my lord may say to me, well, if that's what they meant, they would have put it in the main judgment, and they didn't put it in the main judgment. But there is no suggestion in the preliminary communications, and given time I won't go to it, but my lord wants to look, it's in tab 49 of JA3. Having set out the test that they set out in 93, they then say, provided there's no serious reasons to doubt, then that's okay. So, and then so those are those reasons. As I say, it's very important to keep in mind that all this case is about is whether a patentee can rely upon post-file data. So it doesn't give a concern that patents are going to be granted for things that don't work or things that nobody knows whether they do work or not. Because if the patentee can't provide that data to the patent office...
So why do we have filing dates at all?
Well, my lord, because one still have to have the invention. The invention is dapagliflozin.
You know, why have specifications at all? Why don't you file a set of claims and then you find out later if it works or not?
Well, it's not such a free-for-all as my lord's characterising it, because of course you mustn't forget the test in G221, which is there has to be, the effect has to be derivable from the specification. So what you couldn't do is file a patent saying I've discovered a new paint thinner, and then turn around later and say, well, in fact, now I've discovered that it treats male pattern baldness, and I can have a patent for that reason. That wouldn't pass the first limb of the test. And of course, what the second limb of the test does is it keeps out inventions that the skilled person would look at and go, well, that's completely ridiculous. So it keeps out perpetual motion machines as an extreme example, but other things, going back to the cases that we looked at, that the enlarged board looked at, the Johns Hopkins case, where it was said, this is another member of this particular family, but because the structure was different, the conclusion was, well, that would be implausible, and so no one would think that was right. And even under this test, you still wouldn't be allowed to rely on post-published data because it doesn't pass the implausibility test. But what it does, And so it's for the combination of those two aspects of the two limbs does keep a check on abusive speculative claim.
So that submission suggests there's a distinction between a speculative claim that is not abusive and a speculative claim that is abusive. What's the distinction?
Well, the difference is a claim where one had a massive formula and said all these compounds are active for a particular feature, when there's no, that's completely implausible and clog up a huge field of chemistry. That would plainly be something that would be speculative and abusive. But when one looks at a claim about a single molecule that is taught as being an inhibitor of a particular enzyme, and in fact is, one has to ask, what are the policy reasons?
Right, so let me be very clear. You are arguing that there's nothing wrong with speculative claims. The mischief, you say, is abusive speculative claims.
Yes.
Right. Yeah. And I repeat, how do we distinguish between the abusive and the non-abusive?
Well, it may end up being one of those value judgments that the courts have to apply. But as I say, a patent that covers large formulas or puts a single molecule forward and says this treats every known disease to man is plainly abusively speculative. A person who sits in their armchair, to use the example that's always used, and decides, perhaps for good reason, known to himself, that a particular drug will treat a particular disease, and in fact, to the benefit of all of humanity, it does, one has to ask the question, why should that not be rewarded with a patent? And of course, my lord, even applying the Warner-Lambert test to product claims, one's engaging in a degree of, I think one calls it speculation or looking forward, because one's looking at in vitro data and saying, I'm predicting from this that it will be the same in vivo, I'm predicting it will get through phase 1, 2, 3 clinical trials and it will be useful. So there's always a degree of looking forward and the unknown, whether one calls that speculation or not. Well, look, can I now look at the judgments in apixaban briefly? Just to deal with that. So that is, no, same bundle, sorry. So same bundle, tab 16. Now, just to give ourselves the timeline on this hearing was on the 19th and 20th of April 2023, and that was 4 weeks after the decision in G2 of 21 came out. So presumably after skeletons, but obviously a short time before the hearing. And as we've explained, as my lord knows, my lord applied the same test, same ab initio plausibility test from Warner-Lambert to product claims. And my lord went through the authorities in detail. And what I want to focus on is the actual decision. So can we pick it up at paragraph 91 on page 997 of the bundle? Now, a key point about this is my lord was looking at ground 1, which was whether the Warner-Lambert test, which was a test formulated in the context of a case about second medical uses, should be applied to product claims. And we see my lord saying that at the beginning of paragraph 91. And importantly, it was not suggested by the patentee, BMS, that G2 of 21 would justify this court departing from Warner-Lambert in such a case. And then because of that concession, in paragraph 92, my Lord Justice Arnold effectively reasoned your decision from first principles. And you said that although plausibility originated as a solution to broad claims. The claim has to be justified by a patentee's contribution, even in the case of a narrow claim. And so if it's not plausible that it has the effects, there's no contribution and it's obvious. And then in 94, my Lord rejected ground 2 of the appeal, which was to say that a lower standard should apply to product claims, and particularly the minority view in Warner-Lambert that it should be ab initio in plausibility. And again, at the very end of that paragraph, we can see that it wasn't suggested by Bristol-Myers that G2 of 21 justifies this court in departing from Warner-Lambert, and my Lord rejected it. So as I said before the break, when we say, as we do, that the conclusion in this decision that ab initio plausibility is the right test for product claims is wrong, we don't say that because of the first principles reasoning. We say the first principles reasoning in paragraph 92 is wrong, or for any other reason along that. It's because, contrary to what Bristol-Myers submitted to my Lord Just Arnold and the rest of the court in that case, G2 of 21 does make a difference, as I've explained.
Sorry, I'm not following this. I mean, there's no shame in saying that 92 is flat wrong. So I need to be clear whether you are accepting the reasoning from first principles or saying it's wrong. I appreciate your major focus is a slightly different point, as you were just saying. But I wasn't clear whether you were accepting or challenging the reasoning for first principles.
For the reason I said before the break, I'm not challenging it, because we say that it doesn't matter why we got to this position. This position is inconsistent with the position from G2 of 21 and as that has been applied subsequently. And therefore, this position is inconsistent with the EPO and other member state courts. And therefore, we should no longer follow this decision.
Right.
It's harmonization.
Thank you.
Now, my learned friend made a couple of small points about the fact that permission to appeal to the Supreme Court was refused from this decision. And there's two answers to that. The first one is that, as my Lord Justice Arnold will remember,
Yeah, we need to look at that because it's not just the fact that permission was refused, it's the reasons why permission was refused. Have we got that somewhere?
I don't think...
I know it's set out in the respondent's skeleton argument. I wondered if we had a copy of it.
No.
If not, we can just look at the skeleton. But I think it is important to see the terms in which the reasons given.
Yes, but my Lord, can I just say before my second point is that the Supreme Court's practice direction, paragraph 3.32, expressly says that the Supreme Court's reasons for refusing permission to appeal should not be regarded as having any valid precedence. And if my Lord wants to reference the White Book, it's page 2197 of volume 2.
Right.
So we say, never mind, as well as the point on the facts on that, the reasons why the Supreme Court refused permission has no precedential value.
Well, to be sure, it has no precedential value, but nevertheless, I think one needs to see what the reasons given that they troubled to give reasons. I mean, otherwise, why give reasons?
It's paragraph 63. And so all we have there is the quote that it doesn't raise an arguable point of law. Now that does bring back into play my first point, which was a key finding of the trial judge in the Appendix of Mitigation was that the patent itself made no teaching, no promise about the molecule apixaban. It wasn't particularly highlighted. And therefore, regardless of whether, whatever the threshold, the test, the level of proof is required for product claims, it wasn't going to make a difference in the case of apixaban because of the judge's finding that the patents made didn't teach anything about the molecule apixaban itself. So the point of law would have been academic in Bristol-Myers because it wouldn't have affected the outcome one way or the other.
Why didn't then the Supreme Court say grounds of appeal are academic and refuse permission to appeal on that basis? Because I can assure you that in this court, if we get grounds that are academic, that's the basis upon which we review.
Because the reasons why the Supreme Court refused is whether it gives rise to an arguable point of law that needs deciding now, and it's not an arguable point of. It doesn't give rise to a point that it needs deciding now if it has no impact on the case.
Okay.
Now, a very important part of our case in relation to G221 is how other national courts are applying it. I just wanted to show my lords a couple of those decisions because we've put a number of them in the authorities bundle, and where we submit we get to is that there are multiple decisions that are, we say, are consistent with the approach that we are suggesting is the correct approach from G221, and there aren't any that apply the ab initio plausibility test to product claims since then. So can we start with tab 30 in the bundle my lords are in, which is the Dutch Court of Appeal in the apixaban litigation, and this is the interim injunction decision, interim injunction part of the case. And the reason why it's discussed in this case is part of the defence to the interim injunction was that the patent was hopelessly invalid. So if we can pick it up at page 1372, oh, sorry, my lords, I think my lord Morisham will notice this is a decision of Court of Appeal with Judge Rian Calvin as the chairman. So in paragraph 6.5 on 1372, the court says, according to Sandoz, the test formulated in G221 means this, in the assessment of an inventive step, only a stated technical effect may be invoked if the average expert already understands from the patent application that the technical stated effect is actually achieved with the invention and the problem solved. At least this is made plausible. That position is rejected. So straight away, the my friend's position is rejected by the Dutch court. They then go on to say in paragraph 6.6, the court with BMS is of the opinion that the G221 imposes a consideration of a technical effect that has to be derivable from the application of the priority date for the average expert using the general expertise. And then they look at the word derivable in the next paragraph. And then 6.8, from the consideration of GKB is obviously the Dutch initials for Enlarged Board of Appeal. In G221, it follows that the test does not always mean it is required that the application already includes evidence that the technical effect actually occurred, or that this is made plausible in the application, as Sandoz argue. In paragraph 74 of G221, the Enlarged Board pointed out that an inventive step and sufficiency of disclosure must clearly be separated and on their own merits. Issues of sufficiency of disclosure and inventive step are clearly to be treated differently. And then in the next paragraph, they make the point that I made when we looked at paragraph 77, that the ability to invoke post-published evidence is more limited for sufficiency. And then they say in the last sentence, in the preliminary opinion, it is incompatible with this consideration to interpret G221 in a way in that the assessment of an inventive step, the condition must be imposed. The alleged effect has always been made plausible by the application, as Sandoz argue. And then if we then drop down to 6.11, if the test is met, the patent holder may provide evidence during the patent granting that the effect actually occurs. If that's been provided, the effect may be included in the assessment of inventive step. Contrary to, and then 612, contrary to what Sandoz argue, this doesn't lead to speculative patents. And then they say that's because protection for patents on a purely speculative patent for an invention that is only made afterwards is prevented because it's required that the technical effect is already included in the technical teaching. That's the first limb of the test, and embodies the same invention that is disclosed therein. So,
and they go on to say the patent wasn't speculative because BMS have proved that apixaban worked experimentally, even though they didn't put the data in the application. Do you defend that reason?
I don't say that's necessary.
So you say the reasoning would have been the same if we struck out the last two sentences. So why did the court put them in?
They obviously thought that was a relevant factor.
Yes, that was their reason for saying that the patent wasn't speculative. It's because BMS had the data, they didn't put it in the specification. I repeat my question. Do you defend that reason?
Well, we don't submit that you can derive from G2 of 21 any requirements that you have to, the patentee has to have done the testing before the priority date. So I don't say that.
I think the answer to my question then is no.
I think it is more, yes. They then went on, well, it turns over the page to 615. They then went on to assess whether the criteria were met, and in relation to the first limb, so is it encompassed by the technical teaching, they note that the patent expressly and specifically mentions the relevant effect. So it passed that one. And then in 617, they say the case is different from ones with broad claims, like a Grivo. And then at the end of that, Sandoz did not argue that the average expert, based on his general expertise, would consider the technical effect with the claim compound to be implausible. So we see them there taking into account ab initio implausibility issues when we get to the second limb. And overall in 619, they said that if the average expert can derive from the application that apixaban is a promising candidate, then it would fall within the derive a technical teaching that the effect can be realised with apixaban. And he went on to discuss that on the facts. The last thing I wanted to just to mention in relation to this decision is on page 1377. And that's where the court expressly addresses the decisions of this court in the apixaban case. And they say the English test has been developed the English Supreme Court in a case about sufficiency of disclosure, and they say that they don't consider that to be compatible with the consideration not to apply different tests when doing inventive step and insufficiency. So that's the Dutch court saying they see us as being not applying G221. Now then, that decision was then appealed to the Dutch Supreme Court, and I think we can not go to the details of it, but there was this procedure in the Dutch Supreme Court is there's an Advocate General opinion that was given by Advocate General Robert van Persen, and he essentially
am I right in understanding that the Supreme Court just dismissed the appeal without reasons?
They dismiss it without reasons,
and it follows that we take their reasoning to be contained in the opinion.
And Advocate General van Persen essentially upheld the decision for the reasons that the Court of Appeal gave. Again, making it clear that there was no requirement for the patent to contain data establishing that the technical effect was achieved with the claimed invention. Can we then go on to the next tab, which is a different Dutch case? This is Teva and Gruenthal. non-Dixon case. And can we pick this up at paragraph 4.10 on page 1401? So this was a claim to a formulation of testosterone. And we see 4 lines down, Teva, who was the defendant, argues the claim wasn't valid. And first of all, in 411, they suggested that the claim for an interim injunction should be dismissed because in Germany, in this jurisdiction, the patents were revoked. And over the page, the Dutch court said, well, they're persuasive, but we have to form our own view. And then in 413, on page 1402, just where the top hole punch is, the court said, furthermore, the test to be applied in the Netherlands does not seem to be the same. In particular, the English judgment with regard to plausibility is not the same test to be used in the Netherlands in this case, following the ruling of the Grand Board of Appeal of the European Patent Office in G2 and 21 in a preliminary opinion on inventive step. So again, the Dutch making it clear that they don't think that we're applying G2 of 21 properly. And then if we go over to their reasoning, and that starts on page 1408. And I'm going to ask my lords just to read paragraphs 440 and 441 first, but a little bit of background. The claim was to a formulation containing a range of different components. There was one worked example in the patents that showed the claim technical effect was achieved. The argument was that it wasn't plausible that the effect was achieved over the width of the claim. So if my lords read 440 down to reference 14 in paragraph 441, and I'll make some submissions.
Can you summarise it for us?
Yes, so I can just point my lords.
If I read this in an attempt to understand exactly what it's saying, it'd take me 5 minutes, which we haven't got.
So 440, by the just above the top hole punch, they're considering the submission that the effect should only be taken into account if it occurred, would be thought to occur over the full breadth. And they say in doing so, the skilled person has no reason to think this would not be the case over the full breadth of the limited ranges, or at least that it has not been made plausible. The only issue is that for an average person skilled in the art, using his common general knowledge, it will be derivable, the alleged technical effect is encompassed, proof is not required, and then they say, at the end, they apply a standard that is effectively ab initio implausibility. They say what was known by him does not make the skilled person, given the relatively limited ranges, think that the formulation that's within the claims would not work. So they're applying ab initio implausibility to this, not plausibility. And we see the same point being made in para 4.41. So they're not saying, oh, there isn't enough data across the width of the claim to make it plausible that it works across the width of the claim. They're saying, because it's not implausible that it works across the width of the claim, that's okay. And then over the page at 4.42, the patentee has relied upon post-filed evidence to show that it does work across the width of the claim. So, again, consistent with our approach to G2 of 21. Can I now take my lords to the Spanish Supreme Court in Pixaban? So that's in Authorities Bundle 3. On tab 36.
You've given us a very useful summary of this in your skeleton argument.
Yes.
Is there something that we're going to get from looking at the original document?
I'm grateful for my lord for hurrying me along. What we say this case shows is it was, first of all, it's a court of final appeal, so it's a Supreme Court.
Yes.
There have been hearings in 2 courts below it.
Just to see where you're taking us to, it's 156 in the core bundle, your paragraph 73.
Yes, and Well, let me summarise what we say you get from this. The same argument was run as the familiar one, which was the defendants were saying there's no data in the apixaban patent to make it plausible that apixaban has the activity that it's said to have. And for that reason, it's implausible and obvious. The Supreme Court in Spain followed the reasoning in G2 of 21, saying although they weren't bound by it, it was persuasive and they should follow it. They set out the test. They expressly approved a technical board of appeal of the EPO's decision post G2 of 21, saying that for the second part of the test, the requirement is whether there are reasons to think that it's implausible that the effect is achieved. So they applied ab initio implausibility. And finally, they made the same point that we've seen in other places, that they put to one side the decision of this court in the parallel litigation because they considered that we're not applying the test in G2 21. And I think we've highlighted the relevant parts in our skeleton, and my lords, I hesitate to say you can read it at your leisure because it sounds like I'm setting you homework, but my lords has the point. And then the final one I wanted to look at, and maybe we could do this one in the same way, although I think I need to pick up a point my learned friend made, is in the next tab, so tab 37, which is the Swiss Federal Patents Force in the Swiss equivalent of the apixaban litigation. And they again applied G2 of 21. They too applied a test of looking at whether there were legitimate reasons to doubt that the effect was achieved with the claimed invention, and they explained why that avoids abusive speculative claiming. And perhaps if we can just look at page 1662, just to make sure I can deal with my other friend's point whilst I'm going past this. So in 1662 and 38, they first of all say that G2 of 21 has been considered by a Board of Appeal decision T116 of 18, which in fact was the Board of Appeal that referred the question to the enlarged board, then got the case back having had the answer and had to then apply it. And I'll show you this models this in a moment. And they say, if we look 8 lines from the bottom of that paragraph, the second criterion is fulfilled if taking into account the knowledge of the skilled person on the filing data based upon the original application, no legitimate reasons to doubt that it could be achieved with the claim subject matter. And they point out that a further Board of Appeal has come to the same decision. Then over the page, and this is the point that my learned friend makes, they say if the claim technical effect is considered by the skilled person to be embodied in the invention, or perhaps my lord can just read that top paragraph and then I'll make that.
Which paragraph are you looking
at? The top paragraph on 166.
It's the criterion.
Yes.
Okay.
So the bit that my learned friend likes is that when they say, if you just apply the no reason to doubt test, speculative applications are not prevented. But the important thing is the next paragraph when they say the standard proposed by the board of enlarged board must therefore be understood to mean the 2 criteria are met cumulatively. So the first criterion is that it must be the effect must be recognised from the specification, and the second criterion is that the skilled person must be deduced the effects embodied. And then they say the second criterion for the technical effect is obvious. The skilled person, taking into account the general knowledge of application is filed, experimental data or an express statement on technical effect are not necessary for this purpose. And there's a reference there to T116 of 18 that we're coming back to. However, since the purpose of derivability is to prevent abusive speculative applications, the hood on must not be set too high, otherwise the inventions that are worthy of protection will not be protected. And so what they're saying there is the point I made earlier, which is it's the combination of the two limbs that you have to be able to derive the technical effect from the original application, and then are there any reasons to doubt that it's embodied by the particular invention. The combination of those two prevents abusive speculative claiming and doesn't set the hurdle too high to prevent otherwise worthy inventions of being protected. Now, we looked for academic commentary post G2 of 21, and as we said in our skeleton, we couldn't find anything specific. My learned friend's got a couple of blog posts from Dutch patent attorneys and the like, and we'll see how he develops those. But our submission on those is that those can't be more authoritative than decisions of national courts applying G2 of 21. And so the last topic of the authorities I want to show, my lord, just very briefly, is subsequent Board of Appeal of the EPO decisions looking at G2 of 21. And if we can go to, sorry, we have to go back to bundle 2 for this, apologise. To bundle 2, tab 21. And this is T116 of 18, and as I said, this is the board that referred the questions to the enlarged board, getting the case back now and having to apply the test. And we can pick it up at page 1175, where they refer to interpretation of G2 of 21. And the analysis of that starts over the page in paragraph 11. So the first thing they do, as one might imagine, is they set out the test, and you see they've broken it up into the two limbs in 11.3 on page 18. And they then come on to consider what they mean. And if, sorry, I wasn't going over. They go to paragraph 1178. So page 1178, paragraph 11.4. They initially start by making the point that the requirements have to be cumulative. And they then have some discussion about requirement 1, but I don't want to focus on that. It's not central to this appeal. They look at requirement 2 in paragraph 1111. So the second requirement formulated in order to, namely, the effect must be derivable as being embodied by the same originally disclosed invention. And we see that where they end up is saying the question to be asked can be formulated as it was by the respondents, with the skilled person having the common general knowledge on the following data in mind, and based on the application as filed, have legitimate reasons to doubt that the technical effect can be achieved with the claimed subject matter. Requirement 2 is met unless the question is answered in the affirmative. So that's them applying an ab initio implausibility test to the second limb of G2 of 21. And they go and give reasons why it's not to be a precondition that experimental proof is actually achieved within the claimed subject matter. And again, we can pass over those reasons, but they're essentially the ones that we rely upon. And finally, on page 1185, they're looking at national case law, and they look at the decision in this court in the Apixaban case, which they refer to as D27. And on page 1185, they say, according to D27, the ab initio plausibility standard has to be applied when examining effects in relation to inventive step of product claims. The board's interpretation of G2 of 21 is different from this. in that instead of an ab initio plausibility, the standard in G2 of 21 needs to be applied. And so again, that's the technical board saying that they don't agree with where we've got to on this ourselves. Now, my learned friend relies heavily on another technical board decision, 314 of 20, and he relies upon it to say that there's no settled practice as to the approach in the EPO. Now, we've got several answers to this. The first is that the approach of the EPO was settled by the decision of the enlarged board in G2 of 21. That's the whole purpose of enlarged board decisions, as we saw recognised in Lilly and HDS, and in slightly different circumstances, what the court in John Wyeth looked at what the enlarged board had said and said we should do the same.
How does the EPA decision settle the matter if it's susceptible to differing interpretations and has in fact received differing interpretations in the very body that is charged with applying it?
Well, I'm going to come on to that, my lord, because ultimately there is one decision that he likes, and we have reviewed every technical board decision post G2 of 21 that refers to it, and that is the only one that isn't consistent with our approach. And obviously we couldn't put all 60 or so of those authorities in the bundle. I've got a couple more in the bundle that I can show my lord, or I can give my lord the reference to. But what we aren't at, and this is very important for my lord to understand, we aren't at a score draw at the moment. It isn't 1-1 with two decisions having been reached. There's about 60 or 70 decisions of the enlarged board, the technical board, post G2 of 21. And I'm sure, like we've done, they've looked at them as well, and the only one they found is 314 of 20. So it is also the case, of course, that I've showed you national court decisions that adopt an approach that's consistent with our approach, and there aren't any national court decisions that clearly apply something akin to the ab initio plausibility test in seeking to apply G2 of 21. So, that was sort of the point I was on. I think, given the time, can I just give my lords the references to the cases that it's bundle JA2 tabs 24 and 25, and it's paragraph 6 in tab 24 and paragraph 4 in tab 25. Both of those are clearly applying ab initio implausibility test to the second limb of G2 of 21 when they come to us. The final thing is on the case that my learned friend likes, and I'll let him make his submissions on it, and we can look at, I'll deal with it in detail in reply if I need to. But although it doubts and questions some of the reasoning of the last technical board case I've just shown you, it doesn't actually come to its own conclusion on what the test should be. And that's because they decided on the facts of the case that the technical effect the patentee was trying to rely upon was in fact inconsistent with the teaching of the patents. And therefore it failed at the first limb because it wasn't, the technical effect wasn't embodied by the teaching of the specification. So, although there is no rule of precedent in the EPO, it's, in our terms that would be an overture type decision because they decided it on different basis. And there's no clear statements of this is what we think the law should be. They just raise some questions about the approach taken in T1 and 6 of 18. So, I'll just join these threads together and then I'll move on to the application of this on the facts of the case. So, pulling them together, my lords, we are, unfortunately, on this issue, a jurisdiction apart. We are, as far as we can tell, we are the only jurisdiction applying anything like the Warner-Lambert test to product claims. Neither the EPO nor any member state seems to be applying it. It's important to keep in mind that the concepts of insufficiency and obviousness are different, and the different criteria applies to. The second medical use claims, where the treatment of the disease is a functional feature of the claim, it's necessary that the claim is enabled, and that requires it to be credible in the face of the application that the drug does achieve that effect. But for product claims, where the technical effect is not part of the claim, sufficiency is proved by showing that it can be made. Whether the invention provides a technical effect is relevant to inventive step only. To rely upon a technical effect for inventive step, the patentee needs to demonstrate that his invention achieves that effect. However, it's not necessary that it's done in the specification itself. The patentee can rely upon achievement of a technical effect by post-file data, provided that the test in G2 of 21 is met. We've seen what that test is. It's whether the effect will be understood to be encompassed by the technical teaching and embodied by the same originally disclosed invention. The first is a question of the teaching of the documents, and the second is whether the skilled person would consider the effect embodied by the invention, which is assessed by asking the question, would the skilled person have any reason to think that it wouldn't be? If you pass that threshold, you can rely upon post-file data to show that it does have the effect, and the combination of both the test and the requirement to prove that the effect actually exists means that abusive speculative claiming is avoided. And we say that that isn't the approach of this court took 4 weeks after G2 of 21 came out in the apixaban litigation. And given how things have moved on since then, and how it's been interpreted both in the Board of Appeal and in national courts, we are now in a position where we are out of line with the rest of Europe, and the harmonization principles require us to move back in line.
Right, so can you just specify exactly what are you expecting this court to do about Warner-Lambert and apixaban?
Warner-Lambert, nothing. Warner-Lambert its ratio is about second medical use claims and insufficiency.
Right, so distinguish it.
Yes, it doesn't. That doesn't apply to this case, which is specifically I'm talking.
Right, but I mean, I'm just sorry to be technical, but we can only operate within our own field. Am I right to understand that you're inviting us to distinguish Warner-Lambert?
Yes, in relation to Claim 2. We can't distinguish it in relation to Claim 15.
Right, so what do we do with it in relation to Claim 15?
Claim 15, you're bound by Warner-Lambert, and if I've lost on grounds 1 to 3, Claim 15 is invalid.
And apixaban?
And apixaban, we say, of course, ordinarily my lord should follow a previous decision of this court. Bristol
We
Airplane...
should follow it. We're bound by it.
Bound by it. Bristol Airplane allows certain exceptions to that, one of which is the exception that was set out in Activis and Merck, which allows this court to not follow one of its own previous decisions.
Yes, well, my lords won't be familiar with that,
Sorry.
so we need to take them to it.
We don't have it, but what we do have is the Merck-Serono case, that's tab 17 of bundle 2. And yes, and it's page 1019. And perhaps my lords can read 79, 18, 81 to yourselves.
it's a decision which cannot stand with a settled view of law adopted by the EPO.
And as I said earlier, it can be settled in two ways. One, it can be settled by a consistent view, consistent approach from multiple boards, technical boards of appeal. Or the second way it can be settled is by a decision of the enlarged board. And so it's that further exception to the second exception to Bristol. So, having done, I apologise for the length of it, the law, I was going to move on to application of facts of it just before the short adjournment.
Are you comfortable with your rate of progress?
I am, my lord. I hope I'll finish this topic by lunch, and then I can deal with the lack of technical contribution in 40 minutes or so after lunch. So,
thank you.
There or thereabouts. So as I've said now several times, if we've not succeeded in persuading your lordships on the first three grounds, we're talking about claim 2 only at this stage, and that's claim to the molecule dapagliflozin. And we rely upon the technical effect that it is an SGLT2 inhibitor and has utility either to treat diabetes or as a tool to lower blood glucose. So if we think about the first test from G2 of 21, which is that technical effect encompassed by the teaching of patents? We say it plainly is. That's what the patent teaches that the molecule does. It teaches it's an inhibitor, and it teaches that it treats diabetes. And my learner friend has no submissions to the contrary on that limb. On the second limb, we say that there are no legitimate reasons to doubt that the technical effects were achieved with dapagliflozin. And on this, we'll come on to the detail of this in a moment, but the claimant's expert's view was not that there were legitimate reasons to doubt that it would work. It was that the lack of data in the specification meant there were no positive reasons to think that dapagliflozin was effective. So they were saying, until you see the data, you don't know whether it's active or not. And the second aspect of their evidence was that as far as work that had been done on other molecules, and that's particularly fluorescein, which was the naturally occurring compound, or compounds that are being developed by a Japanese company called Tanabe, the claimant's expert's position was that was not informative as to dapagliflozin. So again, absence of information doesn't cause you, it just doesn't help. Now, our experts had expressly given evidence that there was no reason to doubt that dapagliflozin was an SGLT inhibitor, and we'll come and look at the cross-examination on that in a moment. But the claimants now rely upon what they say is a finding by the judge that Tanabe work gave the skilled person reason to doubt. And that's the dispute on the application of the facts to the law. Now, can we take the judgment to deal with this? And so that's 4 tab 5. You can go to paragraph 243. So the judge notes in 243 that AZ relied upon the similarities between dapagliflozin and fluorescein, which it said would provide the skill team with additional reassurance that dapagliflozin would be an SGLT2 inhibitor. And then he sets out the structure of that, he discusses it, and he comes to the conclusion that it wouldn't give the skilled person confidence, and we're not challenging that findings on this appeal. He then, in paragraph 247, notes that there was a debate between the parties about whether the skill team presented with the patent would obtain and study other documents. And in that paragraph, he refers to a decision of my Lord Justice Arnold in the Fibrogen case, saying that whether the skilled person would go and look up a reference in the patent was dependent on the disclosure of the patents and the evidence. Context and fact dependence. So he then noted that in 249, he noted that the experts had said that the skilled team presented with the patent would see reference to the Tanabe work. Now that was referenced in a narrative sense, in the sense that there was no references to any documents. It just described that some work had been done on compounds a bit like this. And then, as he said, no attempt was made to recreate that kind of search that would have been done to locate that work. And so that is the judge saying, well, there's no evidence to support the skilled person looking at the patent itself would find that work. But he then went on to say that there was a reference in the patent to the prior art, and as we'll come and see in due course, the prior art refers to 4 papers by the Tanabe group. And so the judge then assesses those papers, looks at what they say, and if my lords go over to 251 and perhaps read 251 and 252 to yourselves. So although in the end of 251 he says in his judgment the message they would convey would give the skilled person reason to doubt that dapagliflozin with the SGLT2 inhibitor, he then in 252 goes on to say, but it's not necessary for me to consider whether it would be permissible to rely upon the information in these cross-reference documents to establish the case of plausibility applying Warner-Lambert's. And indeed, if we go on to the very last paragraph in this section, 262, he again says, I have considered whether I should decide these findings of facts that would pass the legitimate reason to doubt test. In the end, I have concluded that I should not do so. So our primary position on all of this is that the judge expressly made no findings in relation to this issue. And if my lords are happy and content that's what's happened, then that's the end of this. There's no finding that it would give the skilled team reason to doubt. And we say we win on the second limb of G2 of 21 if my lords accept it. But my learned friend is relying upon that finding, and insofar as that is a finding, it's relying upon the statement in 251. And insofar as that is a finding, we say there are 2 problems with this. The first is that it requires the skilled person reading the patent to see the reference to the prior art, go and read the prior art, in the prior art see the reference to 4 papers amongst other references, read those and come to that conclusion. And the only witness who said that the skilled person reading, or gave evidence that the skilled person reading the patent would read the prior art was my witness, Professor Potter. The other 3 weren't interested. And although he said he gave evidence that the skilled person reading the patent would want to go and read the prior art, and when he was considering the prior art for the purposes of obviousness, he said the skilled person might be interested in reading the Tanabe papers. He never said, and it was never put to him, that the skilled person trying to understand the patterns would make, if you like, the double hop from the patent to the prior art, from the prior art to the Tanabe papers, and then come to the conclusion that it was implausible. And as my lord knows, many patents and many documents can have references, and the references in them can have further references, and one always has to ask the question, you can't allow people to go hopping backwards through all the documents forever and a day, because it would never stop. As my Lord Justice Arnold said in Fibrogen, it's fact and context dependent. And as we saw in the patents when we looked at the reference to the W0128 patents, it's simply an acknowledgement that it's there. And there's no reason why the skilled person wanting to understand about dapagliflozin would think there was anything in 128 that will be of relevance for them. And so we say our first answer to this, insofar as it's a finding, is there was no case put that this skilled person would make this double hop. The second answer is that the evidence did not support the judge's finding that there would be reason to doubt. I need to do that in a little detail. So could we take the supplemental bundle? So as I said, the claimant's case was effectively the lack of data meant you could draw no conclusions, and no conclusions could be drawn from the other compounds. And let me show you that. So tab 10, and this is Dr. Edwards, the claimant's medicinal chemist, my friend's medicinal chemist. And on page 195, he starts looking at the patterns. And then if we go on to page 199, he starts looking at the claims of the patterns. And then over in 143.2, he's talking about the compound claim 2. And he says, consequently, they would understand that the invention of 211 was the compound for use in treatment of type 2 diabetes. However, the medicinal chemist would know there was nothing in 212 to support the assertion that this compound has any utility in treating diabetes or delaying the onset of disease. Over the page in 143.6, last 3 lines, there's no information that suggests the compound could be an effective medicine for treatment of diabetes. There's no in vivo data in an appropriate animal model. And then in 146, third line, no data provided. As such, the skilled medicinal chemist would not be able to verify the statement that the compound does indeed possess activity as an inhibitor of SGLT2, nor its level of inhibition. And then 147, right at the end, as such, the skilled medicinal chemist could not predict compound 1's ability to inhibit it without testing. And the claimants, the respondents' biologist, Professor Terens, gave evidence to a similar effect. Let me just show you one paragraph of that. That's tab 13 and paragraph 39. Page 236. In my opinion, there's not enough information in the patent for the skilled biologist to make a reasonable prediction that the compound does have the properties it says it has. Now, our experts... oh, sorry, my lord. So that's the first point. The second point about the comparison with other molecules. We go back to tab 11. No, sorry, sorry, tab 10. Apologise. Trying to go too fast. Page 179, paragraph 58. And Dr. Edwards has done a literature search in orientating himself with the common general knowledge. And he says there was some SAR information my lords, SAR, structure-activity relationship, where one takes a molecule, changes bits of it, trying to see which bits give rise to activity and which bits don't. However, as I explained in Annex A, when I read 128, there are significant structural differences between the Tanabe compound and Marcuse structure 1B of 128. 128 is a Marcuse structure that includes dapagliflozin. The skilled medical chemist would therefore not consider that an SAR generated in developments of 1095 would be transferable to the most preferred structure 1B in 128. So again, he's saying not informative. Now, our witnesses gave evidence that they thought there was nothing that would make the skilled person think that it would not work. And the only expert that my learned friend challenged on that was our medicinal chemist, Professor Potter. And let me just show you that finally. So that's tab 15. And Bondle page 261. And if we look at internal page 357, top left, he says at line 6, you agree with Dr. Edwards that the previous work on fluorescein and Tanabe compounds doesn't inform the medicinal chemist about the activity of structure 1B. He says, no, it can't do because there's no activity of the compounds of 1B. And then he asked the question about, because what you're meaning there is the differences between the structures of fluorescein and 1095 are such that you cannot draw any conclusions about the activity of 1B from the structure. You can't draw conclusions, but you can hypothesize. And so my learned friend there has got the answer that you can't support activity of in this case, all the compounds falling within 1B, which includes dapagliflozin, by the comparison with the other compounds. So then he tries to chance his arm a bit more and try and get a bit further. So in 358, he says, indeed, because of the differences between fluorescein and 1095 in structure 1B, there will be reason for significant doubt that the compounds of 1B would have any activity to the number of changes. Answer, that's a different interpretation, is it not, with respect? Saying there's no information about whether they have activity is I think there's a not missing. It's not the same as doubt. That's a different thing. That's why I'm asking you the question. I can be agnostic about it without saying I doubt it. And then perhaps if my lords, just rather than me reading it out, if you could read down to page 359, line 24.
Yes.
And in particular, obviously, I rely upon the last answer on 359. You accept that if the data on fluorescein and 1095 can't inform you about 1B and 128, I think you must agree it can't inform you about the activity of 1 in 211. That's the patent, that is DAPAG. It can't inform you positively or negatively. So where my learned friend got to was not that, having been through all the Tanabe work with Professor Potter and then putting these questions to him, that the witness accepted there was a reason to doubt. It was that the witnesses ended up being ad idem, that both the claimants' witnesses and Professor Potter, after cross-examination, ended up in the position that the Tanabe work doesn't assist in thinking that it's active, but equally it doesn't give you a reason to think that it won't be active either. And so we do challenge the judges, insofar as it is a finding, going back to 251 of the judgments, where the judge said the message that the papers convey, namely that the structural features of fluorescein analogues are important for activity, would give the skilled person reason to doubt it. There simply wasn't the evidential finding for that. Now, my learned friend seeks to defend the judge's finding in his skeleton, but what I will say is notable from that passage in his skeleton is there are no references to the evidence. And he hasn't engaged with our point that I just made to your lordships, that the only cross-examination he did does not support the point that the judge made. all the witnesses was neutral. And when we think back to the test that we say one has to applying G2 of 21, there has to be a reason to doubt, and being neutral about it doesn't get the respondents over the line, keep our post-file data out, and prevent us from relying upon the technical effect, insofar as your lordships are against me on grounds 1 to 3.
Well, on its face, 251 doesn't appear to be a finding based upon evidence of witnesses. Rather, it's based on the paper cited in 250.
Yes, and I realised this as I was going through it. What I omitted to tell your lordship is that in the run-up to that passage of cross-examination, Mr. Mitchison had been through these papers with Professor Potter, asked him questions about them, and then he came to the conclusion based on those papers, which was the passage I showed you. So those papers were squarely in mind and had just been discussed in the cross-examination before he came to his concluding questions and got as far as he got.
Very good. Well, have you reached the point you wanted to?
I have one.
Good. Well, thank you, Mr. Hinchliffe. We'll start again at 2 o'clock.
What, round the table?